Happy Wednesday, everybody. Wednesday. Welcome to the September webinar that my firm, I do every month. I'm excited to talk to you about this subject in particular, which is medical billing experts. If I can do air quotes any more furiously and aggressively, I would. Medical billing experts. And the reason is 90-something% of these people are bullshit. So let me start with that premise. That's my belief. I want to take you back, though, a decade ago and give you my frame of reference, my first experience with medical billing experts, because I was a defense lawyer. I worked for Troutman Sanders. I did a lot of Georgia Power personal injury defense. Georgia Power self-insured up to, I don't know, whatever. And they hired Troutman to do a lot of their personal injury defense. Georgia Power, at least at the time, had more vehicles on the road than any other employer in Georgia. Might not be tractor trailers, but a lot of commercial vehicles. So I did a lot of that work. And I actually had a case against Mike Goldberg and Joe Freed. For the record, I left Troutman and did not try this case I'm going to tell you about. And then they went on and got like a $4-something million verdict, which they deserved, partially because Georgia Power defended the case in such a terrible way. And if you've heard me rant on nuclear verdicts before, a lot of air quotes today, nuclear verdicts before, they're the result, large verdicts are the result of juries being angry with the defense and the defense taking unreasonable positions. So that's what happened in this case. But before I get into the medical billing part of it, as a defense lawyer, my job was to investigate and try to figure out ways that we're going to defend the case. So I had heard, and the partner I worked with, we had heard about a medical billing guy, and we hired him. His name was Lamar Blunt. And if you're like me and you can't say his name without rolling your eyes, you're going to enjoy this webinar. So anyway, we hired him. He did a workup of a similar method to what I'll show you today. His method has changed over the years. And he actually billed us, I don't know, like $80-something thousand, and it got so high that we didn't even feel comfortable using him because we were hiring somebody to challenge the reasonableness of bills or charges at the time, and he charged us more than we were going to save. So my experience with him was pretty terrible. I didn't think that it made sense at the time, for even from the defense perspective, after we got his opinions and really dove in, and certainly after I think Joe Freed did the cross of him. I defended the deposition, and that deposition still sticks in my mind, just how bad of a train wreck it was because the opinions were so unsupported. So that's 10 years ago. Fast forward to today, and if you're on this webinar, you've probably hit a Lamar Blunt, a Hannah Cox, a whoever else. There's a guy named John Cox. There's a bunch of these medical billing experts, supposedly, running around, saying everything costs too much. Well, respectfully, no shit. Everything does cost too much. And we'll talk about the practical effects or the practical reasons why their testimony makes no sense and how to cross-examine them. But I want to start with a background of the different methodologies, at least that I know about, that I've seen in cases that I have. So let me start with this one. All right. So hopefully what you see on your screen is a Health Law Network report. And this is a report from July of 2019. I actually tried this case. I have trial testimony and deposition testimony of Lamar Blunt and a bunch of other ones. So I'll send that out too. Actually, I'll make a note for myself for the trial testimony. I hadn't thought about that. So I'll send that all to you too. So what we're looking at here is, and I'm going to focus on the opinions, and I'll zoom in on these. So one method that these medical billing experts use is to look at the quote, usual, customary, and reasonable charges for medical bills, and apply a percentile to them, or compare them to percentiles. You will know, this will jump out of you because you will literally see percentiles, 75th percentile, 80th percentile, and then usually the letters UCR. And you'll know from there that what the billing expert has done is looked at CPT codes for non-hospital facilities and for doctor charges, and has compared those codes to what certain percentiles are according to the PMIC, which is a database of charges, or sometimes they'll use the VA or other databases, and say, look, the opinion ends up being, look, the 75th percentile is $100,000. Your charges are $150,000. And that's typically where the expert in this scenario will stop. The expert will say, here's the information, and not make an actual conclusion. Expert just says 75th percentile, 80th percentile are these numbers. The charges for this plaintiff are up here. And then it will be typically the defense lawyer during closing that tries to connect those dots and say, hey, these bills are too expensive, shouldn't do it. You will also, everybody, if you all want to squint, this is going to hurt your eyes, so forgive me. You will also almost definitely get something that looks like this, this massive spreadsheet. I have the pricing worksheet tab up on this, and this shows what, in column M here, it shows what the charges were. Each row is a different line item bill. So it shows what the charges were. And in this file, I mean, we have 779 itemized charges. And what you want to be looking for, and I'm going to go, I'm going to come back to the coding review. You should be looking at the geographically adjusted audit. So in these columns are going to tell you what the average right here. I can make this bigger. I guess I can. It's going to tell you what the average usual customary charge is at the 50th percentile, 80th percentile, 70 and 80th percentile, 90, and so on. And then this is after the math, essentially, to the formula has been run. What medical billers will also do is they will supposedly review a bills, and you see this column T, and they will allow or deny the charges, like they have the power to do that. So what they will do is they will say, look, there is a charge for, let's look at this one, see if I can figure out what it was. Okay, here we go. Let's make it real easy. Here's a charge for ibuprofen. It's $5. Let's make it real easy. So this medical biller CPA with no medical training or expertise and no medical degree or anything like that looks at the medical records and says, was ibuprofen, which is this one right here, was it appropriate to give, and did the bills back up, or excuse me, did the records back up the bills? Meaning, is there a record that says dispensed ibuprofen? And if there is, then the medical coder will allow the charge. On the other hand, they will look at some things. I don't know what off the top of my head what Cpt Code 72040 is, but whatever this is, for $120, the reviewer looked at this, looked at the bill, compared it to the records, and decided in his own judgment that the records did not support the billed charges. So depending on who you ask what that means, if you ask the expert, they say, well, the records there's no evidence that this charge actually happened. That's what their answer will be. So it's based like a faulty, the argument would be that it's faulty records, that the records are not supportive of the charges. I take that to an extreme to mean that the doctor charged for something he didn't actually do, but experts will typically back down on that and say, well, I don't know if he did or not, just the records don't support it. So those are the two ways under this CPT code and guidelines comparison model, based on the reasonableness of the charges. That is how an supposed expert will compare and try to offset your bills, your client's bills, by comparing them to other bills by CPT codes, applying a geographical modifier, which is local to whatever area your client's treated in, and determine what the 75th or 80th percentile is. Why do they use those numbers, by the way? because that's the data that's available. They don't have the 62nd percentile. They don't have the 91st percentile. So they're stuck with what the PMIC and other source data compilations have. And they will try to, show that your bills are so far above whatever percentile they choose and is available to them. And then they will also try to offset your charges by saying that the records don't support things. The records don't show that whatever treatment was given actually happened. It's easier in like a physical therapy session for me to give you an example because like, for example, Medicare billing guidelines require for certain procedures or certain modalities require the records to actually say there was 15 or 20 or 30 minutes of this done. And if the records don't say it, Medicare won't pay that. And that's kind of the guidelines that these medical billers will use and say, look, it doesn't meet the billing requirements. Well, of who? Of Medicare. Well, these bills aren't going to Medicare. And that's one thing you can say back. So let's talk about the practical effects of this method and how I think you can challenge it. First, let me lead with the big thing. There's a woman out here who does this work for a company called Elevate. Her name is Hannah Cox. Recently-ish, she has been, and one of the lawyers in my office was involved in this case, at least one of them, she has been struck. She has been struck under Daubert. So let me show you this order from Cobb County, September 3rd, 2021. So just over a year ago. The case is Stewart versus Pugmire Lincoln of Marietta. I don't know if I'm pronouncing that right. If anybody's bought a car there, you can correct me. And here's Judge Leonard issuing an order that found that Hannah Cox was not qualified. I will also show you, forgive me for clicking around here. I will also show you a Northern District of Georgia case. Here it is. Frushtick versus Ferrio Express. Jared Lena and Jonathan Hayes, two very good lawyers, against Quinn Bennett, who I went to law school with. They got Hannah Cox also struck here, and this case is relatively new, earlier this year. So I'll send these two opinions out, or these two orders out, and one order, one opinion, and it will help you. So I would use these as a blueprint when you're going through the CPT code analysis. My issue with CPT codes is if you start with the PMIC, which I have one laying around here, but couldn't find this morning. If you start with the PMIC, that's the database that most of the billing experts will use to find the percentiles. In the introduction to that database, and you will see this in my cross of Lamar Blunt that I'll send you, it says don't do what you're doing with it. It literally says, do not use the percentiles to determine what's a reasonable value of the service. Because the goal of the PMIC, as the intro says, is to help providers set their bills as high as possible so they make enough or make as much money as they can. It's literally a book telling doctors and medical providers, here's how you should charge, and your goal is to charge as much and make as much. I mean, that's our free market system. But then these expert coders use the data within it for a purpose that is expressly disclaimed against, and even stronger. It's probably more than disclaim. That seems like, that seems too weak to say. So I encourage you to get a copy of the PMIC and read the introduction when you're faced with a CPT code biller. On a Daubert level, when you have a medical coder deciding if the charges are supported by the bills, I think that is a very key Daubert motion right there to move one, that the medical biller does not have the ability to make medical testimony and decide what was done and what wasn't. I mean, all this person with no training is doing is just reading records and comparing it to the Medicare standard. Under 403, a reasonable, a confusion of the issues argument, and it doesn't aid the trier of fact. I would argue in this scenario that comparing the bills and the records to Medicare requirements, those standards that the experts use to say, hey, these requirements are not being met, even though they're not real requirements, that's not the issue before the jury. The jury doesn't have to decide if Medicare standards were met for billing records and billing and medical records and medical bills. It's a non-issue. I think you can also cure part of that by taking your treating doctor deposition, and you have to anticipate and you have to know what's going on, and saying up front to the doctor, do you know there's this guy, there's this woman, Joe or Susie, who says that your bills are not supported by your records? Everything that you, and the doctor says, no, I didn't know that. That's crazy. And you say, are you billing people fairly? Absolutely. Are your charges higher than some other people? I would expect the doctor to say yes. And you say, why? And the doctor then you put it on a T and you let the doctor hit it off. And the doctor says, well, I've been doing this work for 2 decades. I do more surgeries than anybody. Whatever. I'm the Hawks team doctor. I do this, and let them just bask in the glory of themselves. I've never met a doctor who doesn't want to do that. So I would also, in that deposition of your doctor, I would pull up some charges and say, hey, they say that this charge, whatever that CPT code we were talking about earlier, that should not be allowed because your records don't support it. And let's say it's it's a test that was run. And you look at the doctor and you say, see that code? This is a test that was run. Did you run that test? And the doctor will say, yeah, of course I did. I also think that on the CPT code method, the way I compare it oftentimes is I say, there's a Michael Jordan and a LeBron James, and those guys make more money than other people. That's in every industry, in any walk of life. If you're one of the best at what you do, you command a premium. And who are these defendants that hurt somebody and then say they can't go to a premium doctor who's going to charge premium rates and get the best that they could get because the bills are supposedly too high? I like to ask during jury selection, if money was no object and you had had cancer, you had some terrible illness, how would you find a doctor? And I let the jurors talk about this and explain, how they would do it. And then I say, would price matter to you? No. And I say, now let's add in price. If it's life or death, or if it's the rest of your life being crippled or hobbled or in tremendous pain, do you put a value on that? Or how do you, I guess the way I phrase it is, where is money a consideration? Is money more or less important than you actually getting a treatment that's going to make you feel better? So I introduce these topics in jury selection. I think that's really important. And I level with the jury and say, these bills are really high. Yes, they are. But you know what? Doctor bills are high. Health insurance is high, whatever you're allowed to say in depending on your case. It's all too high. But at the end of the day, practically, your client is left, and you have to be careful how you say this, but your client is left with those bills. Your client is left owing those bills, which if you say it like that, you're usually in the clear. You can't say your client owes that specific amount because that might not be true, but you can certainly say your client is still responsible for these bills. And that is 100% true. I imagine this is common sense, but I'll say it. I think you want to ask these medical bill provider or medical billing experts, can I go to the hospital and walk in there and say, Lamar Blunt says that my bills are too high, so you need to write them down. You can do that. They'll look at you like a crazy person and then laugh at you and then tell you still got to pay. You can do that. But a medical billing expert has no practical purpose. Now, before I talk about the other methods, let me talk to you about the practical application of medical billing experts. When you frame this issue for a judge or a jury, I think it's important to give a comparison between what this expert is doing and what actually happens in real life. So one rhetorical question, I generally hate rhetorical questions, but one rhetorical question I find myself asking in almost all of my Daubert motions for medical billing experts is this: who is the medical billing expert's industry? Who are his colleagues? Who are her colleagues? Because that's, one of the factors of a Daubert analysis, or I guess two of them, if we put them together, was this methodology created solely for litigation purpose? And then is it accepted in the industry. So I always want to highlight and ask out loud, why was this created and what is it used for? Why is this methodology created and who actually uses it in real life outside of lawsuits? And I've thought really long about this. I've done as much research as I can. And I think the answer is it's absolutely not used in any way outside of litigation purposes. If these experts are coming in to cases and saying all these bills are unreasonably high, then we know medical providers do not use them to set the rates. Medical providers are not using this methodology because if not, they'd have lower bills. So we know medical providers aren't using them. Collections agencies aren't using them. Pharmaceutical companies aren't using them. No one is using any sort of this bullshit method to find out how much the charges should be or how much the value of the services should be, which I'll talk about later. This is a purely driven, litigation-created methodology that is used to keep injured people from getting fully compensated for their medical bills. I think that's a fact. I've said that for years in filings and in arguments, and I honestly, I think at this point it's a fact. You know, there's some facts that are objectively true. There's some facts that if you say enough, you start to believe it's a fact. Certain politicians are really good at that. Maybe it's both for me. I've said it so much that I believe it. But if you know of a practical real world application for this methodology, someone let me know. It's certainly not used by anybody involved in medical services that I can figure out. And I think that's important to give that context to the judge and say, this is some bullshit that they just created, because that's what it really is. You know, the only application I can think of is in Medicare to root out Medicare fraud, but Medicare sets its rates because it's the government. It has the largest payer pool essentially, and it can set the rates of whatever the hell it wants. So comparing to Medicare isn't really helpful when your client is, you know, treating on a lien, doesn't have insurance, or even has, you know, some insurance company that isn't as large as Medicare. And I should have said this earlier, when you're looking at that Excel spreadsheet I showed you, and you're asking the expert about where the data comes from, you need to make sure, and you'll see this in the opinion and the order I'll send you about Hannah to Cox, you need to make sure the expert, or you should highlight, I guess, that the expert doesn't collect this data, doesn't know where it's from, cannot validate the accuracy of it, and like I mentioned, is using it in a way that they're not supposed to use it according to the source itself. But I bring that up because the data in the PMIC is a mix between different charges for different types of patients. What I like to highlight is if your client is a self-pay patient, or, you know, treating on a lien, which still counts as a self-pay patient, your client is not in the same situation as a medical provider that bills something at a Medicare rate, knowing Medicare is going to pay it. So the source data, the expert doesn't know what actually that data is comprised of, where it's gathered, what percentages of the total US charges it is. You know, I think you need to highlight that the expert is literally just looking at a book or a compilation that's online and just shrugging and saying, I guess this is right. This sounds good. One reason that experts use CPT codes and do this evaluation in the way that they do, looking at percentiles for non-hospital charges, is because all this is available, because this information is available. The problem is when you get to hospitals is that UCR information, CPT codes are not used. So UCR information is not available. There are DRG codes. They don't provide what's available about them don't provide enough information or as much information as the CPT codes that are used by non-hospitals. And everything in a hospital is not put on a DRG code. So that brings this predicament for medical billing experts, because they have this methodology that they claim is useful and reliable for non-hospitals, but they can't replicate that same method for hospitals. So they have to come up with something new. And I think that anytime an expert has two different methodologies for essentially the same thing, whether you get service performed at a doctor's office or a hospital, it's still medical services rendered. If you are doing two different methodologies for the same thing because the data limits you to do that, necessarily, one method must be more reliable than the other. Disclaimer, I am not saying that either methodology is reliable. I'm just saying necessarily one must be more reliable than the other. Because I don't think either of them are reliable. So with hospitals, there is a completely different methodology that is typically used. Are you ready? If you haven't seen this, are you ready for your head to explode? All right, let me show you another methodology. All right, this is from earlier this year on a case I have against Kroger, and our client went to Northside Hospital. It's a crazy case. He fell at a Kroger, which frankly, my firm, we don't handle many slip and falls because the injuries typically aren't severe enough, but our client needed a surgery after his fall. That first surgery has some complications afterwards. He needs a second surgery and he dies in Northside Hospital following the second surgery. So it's a wrongful death slip and fall case, which you don't see every day, thankfully. But in this scenario, I want you to look down at the opinions. Zoom, excuse me. All right, here we go. Oh, I guess I can't zoom. Forgive me. Let me do this again. So I don't mean to give you all car sickness. All right, so when you look down at these opinions, what you see is the reasonable value, and you don't see any percentiles. Instead, you see percentages of total collections to total billed, and then you see stuff about operating margin. So let's put ourselves in the mind of a medical billing expert. We have no way to use our supposedly reliable method that we use for medical provider charges outside the hospital. So we have to come up with a new method. We don't have enough data on individual charges. They can't look and say, hey, XYZ procedure costs this much, and here's the data that shows it around the country or in Georgia or whatever area that it is. And so therefore, this bill that's twice it is obviously too high. They can't say that. So what they use is the cost method and the collections method. And I'm going to share my Daubert motion that, let's see, when did we just file this? We filed this in July on this very case because I think we do a better job, frankly, of explaining how the two methods work. There we go. All right. All right. As you can see, same case here against Kroger. And this is what we came up with. So here's how their method works. You start with the data from the hospital, which you can get off the AmericanHospitalDirectory.com, AHD.com. So they start with this data saying this is what Northside Hospital, Northside Atlanta, this is what their financials are. I mean, literally, it's a profit loss statement. So under the collection method, the idea is to tell the jury that based on Northside's numbers, this is the medical billing expert. I'm channeling my medical billing expert. If I'm that person, I say, look, I looked at Northside's financials, and based on my collection method, this is how much they actually collect for the bills that they send out. You might be saying, ding, ding, ding. What about the collateral source rule? Well, they get around that, or at least they try to, by saying, I'm just using collections to value the reasonableness of the service and how much the value of the service is. I'm not using collections to say that something was paid or not paid. It's a very close call, but it's a runaround. So step one, here we go. Step one is you take the net patient revenue, there it is, and you divide that by inpatient and outpatient revenue, and that supposedly gets you your collection ratio, okay? So what the expert decides is how much does the hospital actually collect on the bills that they send out. And according to this expert, it's 28.6% for Northside, Atlanta. Step two, you take, my client's name was Malik, you take the charges and you multiply that by the collection ratio. So here are the charges at Northside alone were $492,000. And that says that the net patient revenue is $140,000. So you've taken the chart or the collection ratio and applied it to your client's charges. You then have to come up with and decide what the operating margin is, and that's how much it costs to run the hospital. You take the operating income of the hospital and divide it by the revenue, and you'll get an operating margin of 3.7%. So if you take the charges, supposedly after the collection ratio, which here in this case, the 140,000, and then you add an operating margin, you should get to the break-even point. You should get to the hospital's break-even point. You then take the break-even point and you add 5%, which this expert believes without a single site and no real expertise in this, or nothing to really justify it, says that hospitals should get 5% in profit. And then you will come to a total method, I guess it's right here, of, in this case, $142,000. So they've taken a $492,000 bill, applied the collection rate supposedly for the hospital as a whole across all departments. I'll talk about that in a second. Added a supposed operating margin across the hospital as a whole, and then applied a completely made up 5% operating profit to then bring charges down to $142,000. This collection method can often be proven to be completely fucking bullshit. Here's why. In this case that I'm telling you about, my client had Humana insurance. So Northside was billing Humana and Humana was paying. How much did Humana pay? Way more than $142,000. Way more than $142,000. Way more than $142,000. So what I can do and will do is take that ledger and use that for impeachment and say, here's how much Northside actually got paid. Here's your collection method is wrong by at least 40%, at least 40% wrong. Why is it wrong? Well, I think the basic answer is that the expert is using a whole hospital approach. This is a really stupid example, but it's the best way I know how to explain it. Imagine going to a Braves game or any sporting event, and you get a hot dog, a popcorn, and a soda. And you decide after the fact, I want to figure out how much that hot dog, popcorn, and soda are worth. Was I billed appropriately? What's the reasonable value of that stuff? Now, if the data is available under the CPT code method, I would go maybe to every stadium in Major League Baseball. I'd go maybe to all professional sports. I'd go, from high schools to amateur, anywhere there's a big group of people, maybe concerts. And I'd say, hey, how much are your hot dogs? How much is your popcorn? How much are your sodas? And I'd be able to compare. And, if the Braves are selling popcorn for $42 and the average of everyone else in the world is, I guess it's a game, so $12, I would say, you know what, I probably got ripped off. And that makes sense to me. That's how I'd figure something out. When I had to figure out my hourly rate recently. So I asked friends of mine, what's your hourly rate? What's yours? What's yours? That's how I did it. What I did not do when I was asking my friends for their opinion on the hourly rate and things like that and setting my own, I didn't look at my overall net profit or net revenue into my firm, divide that by my profit, use an operating expense, and then multiply that by some sort of made up revenue percentage or profit percentage. That would be like looking at the entire Braves organization, everything from player salary, stadium costs, merchandising, employees, you name it, looking at their entire profit and loss statement and looking at how much money they bill out for season tickets and how much money they generate from TV revenue, and figuring out what the Braves operating cost is, what their collection rate is, and then applying a profit to figure out how much a hot dog, a popcorn, and a soda costs. That makes no sense. That makes no sense. But the experts in the medical billing world do this because that's the only data that they have. In this case in particular, they didn't even break it down by department. So Northside Hospital Atlanta is a baby making factory. I think in the Northside system, I think this is true. Somebody can correct me. That Northside delivers more babies each year than any other hospital in the United States. I say that because if you take the entire profit, the entire revenue, the entire financials from the hospital itself, what the hell does babies, what do babies, what is the NICU, the PICU, what does delivery and labor, what does any of that have to do with an orthopedic surgery? Like nothing. What does the emergency department have to do with trauma or with orthopedics? What does any department have to do, any other department have to do with any department that wasn't involved in your client's treatment have to do with the actual treatment they got? And the answer still is nothing. So who cares what the hospital collection rate is? What I would care about is what's the collection rate for this specific procedure. Be as specific as you can, but they can't do that. And plus, if your client is insured, make sure you get the EOB and see what's paid. In my case, there was a $45,000 charge by Northside, and Humana paid double. Humana paid like $98,000 or something like that. So they're paying more. And then you have an expert coming in saying, actually, it's only about 31% of the charge is what's appropriate. When Humana has bargained for a service and paying more than that. So I think that that's one way to look at this. All right, let me take you through the other method, and that is called the cost method, which, spoiler alert, it's going to have the same problems as the collections method. So here is the cost method and how it supposedly works. This uses the cost and collection method. I'm going to scroll up here. Use the same exact data. So you're going to get almost the same exact result if you use the same data and manipulate it in different ways to come to the same conclusion. I think that's the definition of unreliable. So the cost method, you take total revenue and divide it by operating expenses, and that will get you the ratio of how much of what your expenses are to your revenue. You then are going to take that ratio and apply it to the charges. And here you get $135,000. Here you get $135,000. And then you add 5% for a reasonable value, and you will, of course, get to almost the same exact number. Almost the same exact number. So the idea behind it, the methodology, the idea behind the methodology is figure out how much it costs the hospital to perform these services. This is the idea. I'm going to tell you why it's wrong. But figure out how much it costs the hospital to perform these services and add a profit. Why 5% again? You're adding profit. I don't know. Who decided hospitals only make 5%? I don't know. They do generally make 5% or less. That's true, but I don't know why we've pulled that out. Here's the problem. Here's the problem. If this was a case about labor and delivery, maybe it's a med mal case, and the bills are exactly the same as what my client's bills were, $492,000. Or if this case was about, I don't know, what's another hospital department? If this was in the emergency department and it was an emergency room bill of $492,000, using this method, the value of services are always going to be the same. Think about it. You're using entire hospital data. So if you have procedures performed in orthopedics, or if you have charges that are specifically nursing or pharmaceutical or ER or labor and delivery or anything, all that matters is the total billed amount. It's not actually valuing the service, it's valuing the bill, because all services don't cost the same. We can, I think, can agree if there's a bill for $1,000 for labor and delivery services, and a $1,000 ortho bill. The cost of those services are very, very, very rarely going to be the same, even though the bill is $1,000. And we know because hospitals don't set their bills based on the cost necessarily, or at least that's not the only consideration. So if you have a $1,000 bill from any department or any combination of departments, using the cost method, it's going to be reduced down, let's just say, to $300. If you have a different $1,000 bill with different services, it's going to be reduced to $300. If you have an even different bill with different services, it's going to be reduced down to the same amount. So it's a hospital-wide cost, supposedly, method, but it has nothing to do with the services that were actually performed. It's just based on the total bill. Now comes the question of how much do services cost? In this case, I haven't done it yet, but I'm going to. I'm going to depose Northside Hospital. And I'm going to say, how much does this shit cost? And let's see if, I don't know if Northside's going to tell me, but I think that if you do a 30B6 of a provider, especially one like Northside, who has, a good reputation, who is one of the few remaining hospitals as Atlanta Medical Center closes down in the next, whatever it is, 2 months, you should go right to the source and ask those people. So I expect to have a deposition. I'm going to have a deposition of Northside, and I expect that some Northside representative is going to answer my questions of, are your bills reasonable? Do you overcharge people? I'm going to also ask, how much did you actually collect for this? And to prove that the collection method is wrong, and I'm going to ask the cost method. And I almost guarantee, or at least I expect, that the Northside folks will say, yeah, this information, this methodology makes no sense. This isn't how we set our bills, and this has no application to us. So that's my grand plan. And that's what I expect to do, because I don't need to be the mouthpiece. I can get Northside to speak on their behalf, and have somebody at Northside, criticize a medical biller that the defense hired. So I can say to Northside, do you know this guy's running around town claiming your bills are too high, claiming that you're being unreasonable, claiming that you're ripping people off? I mean, that's what it is. And let them defend themselves, because they have the most to gain or lose, frankly, from it. And my client still owes those bills, and I get to reiterate that again. So, let me pause here for a second, and make sure that I don't have any questions, because I've run through a lot. To recap, I have run through the CPT code method that's used for non-hospitals. That method relies on usual and reasonable customary charges, supposedly from databases like the PMIC, the Medicare database, and other collection sources. And it's a line item by line item comparison. And usually it's a comparison to certain percentiles. And typically the expert does not go as far as to say these charges are unreasonable. They leave that to the defense lawyer to argue in closing. This method, which is used by a lot of folks, there's at least 2 cases I know where experts using this method have been daubered. And I'll share those opinions with you. One's an opinion, one's an order, and that way you can see the exact way that the lawyers, one of them being one in my office, got to the conclusion. Then you turn to hospital bills, which can't use that method and is using a different method based on aggregate data from the entire hospital institution. And that aggregate data is manipulated by the expert to supposedly come up with how much the hospital would have collected on the bill and how much the cost would have been, how much the cost of the service would have been plus a profit. Those 2 methods, the collection and cost methods, will be the same regardless of what department your bills are in, because it's looking at aggregate data and not looking at the specific services rendered. In fact, in my case, the testimony from the expert was that he didn't even look at what the services rendered were. He just looked at the total billed amount. You'll know the difference because on the CPT code method for non-hospitals, you will get a crazy spreadsheet that will make your eyes water. On the other side, you will get, I guess I can show you, I didn't. You will get what looks more like a financial statement. And here's what it looks like. you will get something that looks like this, which is really just copying and pasting information from the American Hospital Directory about the financials, which are done quarterly for hospitals, and then applying that information with made up ratios to determine, supposedly how much the cost or how much the collection of those bills were. Those are your two methods. I have admittedly not seen an order saying that the cost and collection methods are improper and do not support Daubert. I imagine that will probably happen soon, but I haven't seen that yet. And on those methods, I think you want to focus on the gap between the evidence. So under the Daubert factors, the methodology has to be reliable in the sense that the data that is used has to support the conclusions that are drawn. And if the gap is too wide, the gap between the data that is used and the conclusions that is drawn, the method's not reliable. I can think of a lot of stupid examples, but if I look at just my law firm financials, and then I'm going to extrapolate and say that's what all personal injury law firms across the entire country are like, that would be kind of crazy. And most people would say, look, it's not reliable because you're only using your data and you're extrapolating it to this huge data. The cost and collections method is sort of the opposite. You're taking all this data from a huge hospital and you're using it to look at just this data, which is your client's bill. The Northside's revenue is what, $7 billion? Yeah, $7.002 billion. And even a $500,000 bill is a significant bill in normal life, but when your revenue is $7 billion, you're using such an aggregate and large amount of data to extrapolate to just a very small conclusion using departments that have absolutely nothing to do with your clients, the services rendered to your client, or the client's bills. So I think it's almost like a reverse of the example I gave you. And that's where I think these methods are most susceptible to attacks. So that's what we've covered. Does anybody have any questions? And I'll pause for a minute here. These last few webinars I've done, I've had guests on and other people helping talk. And I forgot what it was like to talk for 45 minutes without any feedback or anything from anybody, as these webinars unfortunately do, where I can't see your faces. All right, let me go then to some other points that I think are helpful, especially in the cost and collections method. Well, first, let's start even generally. Remember that experts, the party offering the expert, has the burden to show that the expert has admissible, reliable testimony. So it's the expert's burden. It's the other side's burden. One of the factors in the Daubert analysis that I think is helpful in this is peer review and publication. Now, if expert testimony is based on experience, like a treating doctor or an orthopedic surgeon who's giving an opinion that a surgery was or was not necessary, typically you're not too worried about peer review. The orthopedic opinions, for at least for a doctor who is an orthopedic surgeon or is a neurosurgeon, has gone through medical school, has gone through fellowships and internships, you're not going to get very far challenging that expert who gives an opinion about XYZ, and you say, what is the peer review material that you rely upon? You might be right that their opinion is nonsense and there isn't peer review data supporting it. But most times a judge is going to defer to a 20-year surgeon and say, hey, if you say the peer review information isn't there, you can show that on cross, but that is not going to alone, at least, cause the expert to not meet Daubert. In this scenario, though, there is not a single peer review article that shows that, and that's the key, peer reviewed, that shows that the defense methodology on the cost or collections method is reliable. So Lamar Blunt, for example, Lamar Blunt, for example, claims, and so does Hannah Cox actually, they both claim that they went to two different professors at Johns Hopkins to get peer reviewed. They claimed that Hannah Cox went to a guy named Dr. Anderson and claims that her company Elevate gave Anderson the methodology for how their billing method works, and this is under the CPT side of things, and that Anderson kind of gave it his stamp of approval. What Blunt did when he found this out is he said, well, I'm going to go do that too because my competitor has this letter, and he goes and gets a letter, and that letter is from one of Anderson's colleagues because Anderson was retiring or not doing this anymore. That's not peer reviewed, first of all. If I call somebody and say, hey, can I pay you to look at my work and tell me it's good? That's not peer reviewed. And second, at least for the cost and collections method, that is not the methodology. Repeat, that is not the methodology that was reviewed. Blunt and Cox are both very wishy-washy about what methodology it was. In fact, I've never seen the letter that Blunt says he got, because they are trying to say, conflate their methodologies. One person that Lamar Blunt at least relies upon claiming that this person, his name is John Schneider, he claims that John Schneider has done peer-reviewed work that shows that his hospital collection cost methods are reliable. So what I did was I wrote to John Schneider and said, hey, I'm Mike. I've got this case. I know you don't know me. I don't know you. Do you know Lamar Blunt? Here's what he says about you, and he's relying on your work. And I will share this with everyone if you ask, or I'll just share it anyway, even if you don't ask. Here is what John Schneider said. Blunt cites his report that's in an FDCC journal. That's the one publication, if you call it that, that Blunt says, look, here he points to and says, look, there's John Schneider doing this similar method. So yeah, there's a peer reviewed. Note though, John Schneider, the author of the supposedly peer-reviewed article, says, I myself do not even cite the article in my own expert report. By only citing my brief, Mr. Blunt appears to be taking an incomplete shortcut that, in my opinion, could lead to a misinterpretation of the overall approach. And then he actually, on his own, I didn't ask him about this. He does apparently have some history with Blunt. According to him, they've talked at certain points over the years. Blunt maybe wanted to work there or something, but that he goes on to say Blunt doesn't seem to have the education and training necessary to do it, that he's, I don't mean this in a bad way, just a CPA. And as opposed to John Schneider, who does actually help pharmaceutical companies and set prices. I mean, that is his real job. And he does not use the hospital collection or cost method to do that, which, going back to what I was saying earlier, the real world application of the Blunt, Hannah Cox, John Cox, all that, their methods are useless. They have no real purpose. So that's something I think you should target, is really focus in on what are the peer-reviewed, there's none, what are the peer-reviewed materials that show this. And it's crazy to me that this has been going on for a decade and there aren't any peer-reviewed articles, at least that I know of. And I think the answer is because everybody's afraid to do it, because they'll be criticized by their peers by how this makes absolutely no sense. I mentioned that I used the hospital or the Humana EOB to show how much, in my case, Humana paid Northside. That if you can do that in your case, that is extremely helpful for a Daubert challenge, and if necessary, later cross-examination of the witness. But it does put you in a weird spot, right? It does put you in a weird spot because you have to then talk about collections and you have to talk about health insurance. So that is a winding road, unlit winding road with lots of cliffs. So if you think you're going to need to do that, make sure that you think about the effects of how that will affect the collateral source rule, whether you can do what you want to do, and some other things. So I would bring that topic up very early with the judge, maybe through a motion in limine, but not to exclude a motion in limine to admit the evidence you think, or however best your scenario fits. Make sure you mention that in your Daubert motion or in your cross-examinations that, and the expert should admit this, if for the hospital charges, if they had line item data where they could look at procedure A to procedure A, cost A to cost A, procedure B to B, and so on, like they do with CPT codes, that method is more reliable. Again, disclaimer, I'm not saying any of the methods are reliable. So with that, you should be able to get the expert to admit that the CPT code method would be more reliable, but they can't do it because they don't have the data. And I think a really good argument is if you're making a methodology based on limited data that you know could be more accurate, the reliability of that is suspect just to begin with. And then ask the experts about their professional experience. You know, Hannah Cox worked for a medical provider and actually was in charge of setting the rates. And if you ask her, which you don't need to, there's depositions out there, but she's just a good example. If you ask her, hey, Ms. Cox, is the method you just told us about that you want the jury to do, is that the methodology you used in the real world to when you were setting rates? And she will say, no, of course not, it wasn't, which I think is really important. So I hopefully covered a lot. Hopefully I did a better job, frankly, of explaining these methods to you as opposed to the experts, because I don't think they do a good job, which I don't really want to educate them, because when they tell the jury, I don't think the jury gets it either. But practically speaking, if we zoom out all the way and we think about how this will affect a jury, I think that juries are predisposed to think that you're not going to pay the whole medical bill because they generally know how health insurance works. So this is really, I think, an in by defense lawyers to get in the back of jurors' minds and have them thinking, oh, he doesn't really have to pay these bills back. She doesn't really have to pay these bills back. And I think it's really important to come up with very specific, effective language to address that your client is still responsible for these bills. Your client is responsible for these bills. You know, your client still has to satisfy these bills. Or, you know, if your client doesn't have to, then it's that the Georgia law says that your client's entitled to recover the reasonable charges and get who gets left holding the bag if the jury awards less. Even bigger picture, if you have a case, which I've got a couple of these, maybe more than a couple, where, you know, it's your standard client gets, I got one I'll give you. My client got rear-ended in a car crash. A good policy that hit him from behind, so there's a lot of money. And he has, you know, neck, back, and shoulder pain, and he ends up having treatment on all those areas. He has never had complaints of pain in any areas before. No medical records, no treatment, no nothing. Nevertheless, and there's good property damage here. Nevertheless, the defense goes and hires a biomechanical engineer to say the force isn't great enough. They hire a orthopedic surgeon to say couldn't have been hurt. Fun fact, the biomechanical engineer says the force wasn't great enough to cause injuries. And then their orthopedic surgeon says, yeah, there were injuries, definitely injuries caused by the crash, but not as severe as the plaintiff claims. And then they go and hire a billing expert. When you put those three together, the evil triangle, maybe I'll coin that. If you can show, or if they take, let's say, I'll put it this way, if those three experts take unjustified, unreasonable positions, highlight those, exploit those, scream up and down about those. Because if you're able to say, look, this is a car crash, and instead of a car crash where it's obvious that somebody caused the injury, and it's obvious our client is injured, and instead of just treating this person right and saying, hey, we're sorry that, you know, you got in this car crash, we'll certainly pay your medical bills and give you some money for pain and suffering. What the defense has done is, you know, they've decided, I'm going to say you're not hurt, you couldn't have been hurt, and if you were hurt, you know, you shouldn't have been billed so much. The example I use, and I'll do this pretty quickly, is, you know, when I was a kid, and this is true, I broke a car window playing baseball in the street. I literally broke a car window. And my parents said to the neighbors, shit, we'll pay for the window. That's what good, honest, normal, reasonable people do, right? That's what you teach kids to do. You say, hey, you made a mistake, I'm going to fix it. In lawyer world, what would happen is, if an insurance company was involved, is they'd say, really? Hold on a second. And they'd hire a biomechanical engineer to decide if the force of the baseball could actually break the window. And then they'd hire some window expert to say, yeah, the window was probably cracked already. You were already hurt. You had a pre-existing window injury. And it's really the result of that bump you hit 2 months ago on the road, that pothole you went over, and not the baseball that flew through the window. And then once you told them, hey, the window costs $200 to repair, they'd go and get a body shop that they're really good friends with and say, $200 seems high. How about we give you $31? In real normal life, I mean, I'm from New Jersey. If that happened, I think one neighbor would go and punch the other neighbor in the face, right? I mean, like they'd be like, that's what would happen. There'd be a fight on the street. You obviously can't do that in court, but that is what is happening. That is what is happening. So when you have an expert to take these unreasonable positions and they all go together, especially with the billing person, I think you can kind of shrug and say, hey, what you say doesn't matter. And present it to the jury as, yeah, they have this guy questioning bills, but the bills are the bills. Here's Northside saying the bills are the bills. Here's Dr. So-and-so saying my bills are reasonable. What's that guy talking about? And kind of just dismiss him and write him off. And I think that can be very effective if you have built up enough credibility with the jurors by dismantling or showing that the other experts are unreasonable as well. I think of the billing expert as the icing on the cake, either in getting to show the jury that the defense is taking unreasonable positions, or it's the third nail in your coffin in your case. It's one of the two. It's either the jury's so mad about the biomechanical engineer and the orthopedic surgeon that by the time they get to the billing guy, they're like, really? The ball went through the window, pay that man. Or, you have lost credibility somewhere along the way and they're saying, wow, not only was he not hurt, not only did he have a pre-existing injury, he's got these unreasonable bills. The last thing I'll say is, and I haven't done this, but I've been waiting for an opportunity. Last thing I'll say is, I think if you can get a billing expert like any doctor to go to an extreme, I have a case right now where a hired defense expert claims that the surgery that my client had was below the standard of care, that it was medical malpractice to have this surgery. With a billing expert, if you can, in the billing expert vein, if the billing expert says, yeah, the bills are unreasonable and your client was taken advantage of by the doctor, in either scenario, that's not your client's fault. Causation is still there. The causal chain has not been broken. The chain is there's a crash or whatever happened to your client. They go get medical treatment. The medical treatment is or is not above the standard of care. If it's not, they wouldn't have been in that situation but for the car crash. If it is above the standard, they wouldn't have been in that situation but for the car crash. Then they're billed. If the bills are unreasonable, they wouldn't get the bills if they didn't have the surgery because they were in the car crash. I mean, you see where I'm going with this. So I think that if you have a very strong billing expert or orthopedic surgeon for that matter on the defense side, I think that in some ways you can get to the same conclusion, even if they're right, which is poor my client who got railroaded or got bad medical treatment, then got railroaded on the bills. Man, none of this would have happened if he wasn't in that car crash. So to me, a billing expert almost defeats the purpose, because even if they're right, I think you tell the jury this, even if the billing expert is right, all that means is my client got taken advantage of and wouldn't have if whatever caused them to need the treatment didn't happen. Car crash, fall, shooting, whatever it is. So I think that this category of experts can almost be self-defeating. Okay. That's all I wanted to share, maybe a little more than I wanted to share. I hope this really helps. And I really appreciate y'all hanging with me. I'm going to send out a comprehensive email after this about showing or giving you everything I showed on the screen. If you're watching this on YouTube down the line, weeks, months, years later, I'll save my email email me and I'll send it to you after the fact. But for everybody attending, I'll make sure that I send it out in the next couple days. If you have thoughts or questions, this is, if you haven't caught on, one of my favorite topics to talk about under the law, because I think it has, because I've been on both sides, and I think it's really interesting, both in a methodology, looking at the methodologies, applying the methodologies, how it relates to Daubert, and then ultimately how you're going to, how this is going to be presented to the jury and how you can combat those things. All right. I have two questions I will answer. First, how much is Deer Park paying me for sponsorship? Not enough. Second, another question, any thoughts on arbitrary pre-suit reductions? I assume you mean for medical bills. So I had a conversation with an adjuster recently where he said, well, we've reduced your medical bills down. We've reduced your client's medical bills. So that's why we're only offering whatever. What I like to do then is I send a nice letter to the insurance company that says, for body damage on a car, you guys have preferred vendors where obviously you agree to their rates and you believe their work to be reasonable. Who can my client go to get treatment that you will say they have reasonable rates and provide good service? And that usually, that kind of challenge usually kind of puts them in their place, frankly, and you have a very different conversation. The only solution, though, if they're going to hold fast and firm and say, your $100,000 bill is really only worth $40,000, and that's why we're only going to offer you $60,000, your only option, like always, is to file a lawsuit. And that's how lawyers like me have jobs, because, the more pre-suit cases you have necessarily, and the more you settle, oftentimes the lower value, the lower the insurance company value is, or the lower the value the insurance company is going to place on your claims, because they know that, you're willing to settle, which isn't always a bad thing. It means a lot of cases, most cases, should be settled, and a good bit of them should be settled before filing a lawsuit. Probably, again, the majority. But when you have cases where, the defense has just decided we're going to disregard medical bills, my solution is put that into suit as soon as possible. And I guess I'll add something else I've done, or at least wanted to do. We've been using summary judgment in my office as a sword a lot more than we ever have, both on terms of liability and causation. So what I've told myself I'm going to do, which I haven't had the opportunity to do yet on a new case, is if there, before a billing expert is disclosed, or frankly, even before an orthopedic surgeon is disclosed, if I have causation in the medical records, I'm going to move for summary judgment on causation and say, here's the medical provider's records that says, the crash caused these injuries. And it's disputed evidence, because they haven't gotten hired an expert yet. It's disputed evidence, or excuse me, it's not disputed, it's indisputed evidence, because they have no evidence to say otherwise. And I like the idea of filing that motion, because it only gives them 30 days to go get some disputed evidence. And same goes with bills. If you can get a statement from your treating doctors saying that the bills are reasonable and necessary, then you should be good. And frankly, with the law, and I don't know the site off the top of my head, but the law that allows the patient, the plaintiff, or a family member, if it's a wrongful death case, to testify that the bills were linked to whatever event caused the need for the treatment, that alone, an affidavit from your client alone, might satisfy, proving that the bills are reasonable and necessary, coupled with probably some records. So, and that again puts the defense in a tough spot where they have 30 days to challenge the bills and show some disputed evidence. So rather than go through discovery, 6 months of discovery, and then they decide, oh, I'm going to go hire somebody and I'm going to hire this person. And then you wait around and you do your discovery depositions and eventually your trial depositions. You can force their hand and say in month 3 of discovery, here's my motion for summary judgment. There's no disputed issues or disputed facts on causation or the reasonableness of medical bills. And then they have to make a choice right then. Am I going to go hire an orthopedic surgeon or whoever? And am I going to go hire a billing expert? And that way you're not submarined later, 9 months, a year later, in one of my cases, 2 years later, where it's like, oh yeah, this case isn't going so well for us. Maybe we should go hire a billing expert. Maybe that will help. No, it won't. It won't help at all. It's going to make you worse. But that can then cause them or force their hand and make them to make a decision. So hopefully that answered that question. But anyway, I appreciate y'all joining. There's some names on here that I don't know, some other names from people. I see somebody, for example, I saw at a school recently at a back to school day or whatever it was. So for those of you I have seen, thank you for joining me. I'm glad you could see me, and I apologize I can't see you in this format. To everybody I don't know, when I send this email out today, tomorrow, whenever it is, with all the materials, please reach back out to me. Tell me about you. Let's hop on a phone call. Let's hop on a Zoom call. Let's go get lunch. I'm going to lunch right now or right after this with somebody I met through a webinar. That's part of the reason I do these things. I like to share what I know. I like to hear feedback, and I like to meet other people. So please, y'all, have a good day. I end some of these by going through, something that's on my mind. I had something to share today. I'm going to wait on it though, just to respect your time, and make it to my lunch on time too. But yeah, look for my email. Thank you for joining me. If I can help you with anything, let me know. And I'll make sure I include my contact information if you don't already have it in the email I sent out. Adios, everybody. Have a good rest of the week.